A law professor says defence lawyers are still exploiting rape myths, and it's no surprise many rape victims regret taking their cases to court. Elisabeth McDonald from the University of Canterbury has listened to audio recordings of 40 rape trials where the defence argued sex took place by consent. She says it's still routine for complainants to be questioned about the clothes they were wearing and why they didn't scream for help, fight back or go to the police more quickly. Her analysis of the trials has resulted in a 568-page book. It's being made available online for free. And with us now, Professor Elisabeth McDonald. Ata Marie.
Good morning, Susie.
I have to say, the first thing when I read this morning made me think that must have made incredibly awkward listening to all these trials.
Yes, well, I have to say it wasn't just me doing the listening. I had 3 other researchers to share the load of it. But yes, I think all of us found that it was a very difficult process. And we've all had long research histories in this area. So,
what did you discover?
Well, a few things that we weren't expecting. I think one of the things, that the major reason for doing the work was to figure out why complainants still, after a lot of years of well-intentioned law reform, are still reporting that their experience is re-traumatising and that they wouldn't go through and wouldn't recommend anyone else did. So we wanted to know, by actually looking at real cases and about what complainants were experiencing, why that was. So we annotated the transcripts with episodes of what we called heightened emotionality. When were they really distressed? When were they unable to speak? When were they getting angry? And to see what the triggers were for that, or what we think the triggers were for that, and to see whether that questioning was necessary or whether that could be done in a different way. So we were particularly looking for when that happened, if rape myth was part of that reason, which it was. So the kinds of things that you were just talking about, but also the requirement that they should remember the minute detail of sometimes quite peripheral matters related to the events in issue. So that was also a cause of some concern for them.
So some of these questions that people were being asked, how would you characterise them?
Well, I think it's important that obviously the defence can cross-examine and they can challenge and they can put an alternative scenario. That's all fine, but it's how that happens, and it's trying to reduce the possibility of re-traumatising. So the kinds of things that kind of are let to ride a bit at the moment in the current trials that we listen to are things that are kind of mocking and belittling or kind of scoffing at her language choices. And some of those things just really aren't necessary in terms of getting to the truth.
Can you give me some examples of how the sorts of questions that would be asked that would effectively lead to people being humiliated or re-traumatised?
Well, sometimes they might struggle to describe what actually occurred to them. So in one case, the woman was sort of being asked, well, what kind of penetration was there? And she ended up saying, he was rooting me. And then that word rooting got reused in questions for quite a long time after that, in a kind of patronising, put-down kind of way. And so those are the kinds of things that don't really get stopped, but we think adds to the kind of negative experience that the complainant has, and it's really not necessary. And we talk about a range of different things that could happen. So, for example, in situations like the cases we looked at, where the issue at trial was consent, there's no real need in most of those to ask the complainant to describe the actual act of penetration. That could happen by an agreed statement of fact. So there are a range of things that could be done.
I appreciate your time talking to us this morning. That's Professor Elisabeth McDonald from the University of Canterbury.